And welcome back to Legal Matters, everyone. I'm your host, Alan Jones, and with me now is Mark Brynteson, the managing attorney with the American law firm. Legal Matters is a half-hour informational news call-in show devoted to a variety of legal topics of interest to you, the viewer. We have attorneys standing by right now to take your call at the number on your screen. That's 815-394-1776. And they'll provide you with free information regarding your issue. So call now and throughout the next hour. In the opening statement tonight, we will be discussing the topics of personal injury and bankruptcy. Now let's remind you of the multiple practice areas of the American law firm. The American law firm is a general practice law firm concentrating in divorce and family law cases, bankruptcy matters, personal injury claims, criminal traffic and DUI issues, wills, trust and probate matters, real estate and business transactions, along with immigration and naturalization services. So feel free to call now and discuss any of these areas with attorneys who are standing by. Mark Brynteson is with us. Thanks, Mark, for being with us, and welcome to the show.
My pleasure. Good to see you again.
So we're starting with personal injury issues. So we'll start with the value, I suppose. What is the value that insurance companies put on personal injury cases?
It's a good question. It's changed over the years. Several years ago, you may have heard it's 3 times your medical bills. That was sort of a standard years ago, but not anymore. Insurance companies have become very sophisticated, super sophisticated in valuing claims. They have computer software that one particular large insurance company in the country developed. The program's called Colossus, where they put all the information in there and it spits out a number. But it's very detailed. The metrics they use, you can't believe it. It's so specific, it'll give you the difference in a jury verdict between Cook County, Winnebago County, DeKalb County, Boone County. So you have to really be on your game as a plaintiff's attorney to know the value of a case in each county.
So it's not just a matter of this is what it's worth. There is obviously much that goes into it, and that's changed just recently.
Oh, absolutely. For instance, when some insurance companies base their settlement value off what the jury verdict will be, and since that's different in each county, you have to know what those ranges are. And what ends up happening is they'll take and see what's the potential jury verdict range for this particular case. And then when you're trying to settle it before you would file suit, they're going to take and say, okay, you can put the same amount of money settling for this amount as you could if a jury verdict. Now that's important to the plaintiff's lawyer and the client, because that means you don't have to expend a lot of cost, litigation cost in the trial by bringing your expert witnesses in, etc. That's very expensive. So it's more economical to settle out of court. However, you need to know what the value of the claim is, because you want to put the same amount of money in your pocket as you would if you got a jury verdict.
Sure. You have to know the basic ballpark of what you're talking about.
Right, and there's jury reporters that attorneys have access to. That's why you should always come and see an attorney before you settle a case, even if you're settling it on your own, to find out what the true range of value, the high and low value is for your case.
Okay. When it comes to a personal injury case, I guess, how do you know if you got a slam dunk case, I guess? How do you know for sure?
Well, you know, there are no slam dunk cases anymore. Everybody remembers OJ. There just are no slam dunk cases. One of the little known things about a jury trial is, for a personal injury case that's over $50,000, there's 12 jurors that end up sitting on the jury, and you pick them from a jury pool. You may go through 50 people before you get those 20 people that are going to sit on the jury. The key is the insurance companies know that they're always going to get, the jury has to be unanimous. All 12 of them have to agree on the verdict or the amount of money that they're going to give you. So when you're doing voir dire, that's the legal term for doing questioning of the jury before you pick them, you're trying to see which people have a bias towards your case. And interestingly enough, the defense always tries to find those individuals that will hold out, because 1 or 2 jurors could stalemate the jury and they can pull the jury down from where maybe 10 of them want to be, so they all get out of there. So, you know, they can leave and it's not going to be sitting on a jury for 2 weeks.
Yeah.
So it's very important who's on that jury, and the insurance companies know that they're going to get 1, 2, 3, 4, people on the jury that are going to be very conservative, and they just don't think the claim is worth what it should be, and you're always dealing with that.
Yeah. Speaking of worth, how do you look at a suit and decide if it's significant enough to sue over?
Well, the suit I'm wearing I like, but realistically, you have to value the case. Well, let's step back. There are different ranges that you can sue for in court that may make it feasible. There's small claims that's under $10,000. There's arbitration, which is between 10 and 50, and then there's over 50. So depending on what the value of your case is, you can pick one of those because the litigation costs are much cheaper for the lesser amount you're suing for. So one of the things is to be very practical and realistic about what your claim is worth, and that's the attorney's responsibility to make sure that he gives you that range that's really practical. So you have to pick what's the value of your claim, and then sue in the particular court that is going to be more economical, less litigation cost, etc. If it's a big claim, big injury, you're going to be in what we call the L cases in Winnebago. You're going to be in over the $50,000 range. That's going to be in what's called an L case.
Okay, so the best idea, consult an attorney.
Absolutely.
They'll give you the best idea.
Absolutely.
Okay, we have more coming back with Mark Brynteson in just a moment. Stay with us, we'll be right back.
Picture experience. Legal experience in many areas of law. Dedication. Giving full attention to each client and their individual legal needs. Affordability. Offering simple flat fees and payment plans. Now picture the American law firm. Call the American Law Firm today at 815-394-1776 for your free consultation.
And welcome back. I'm your host, Alan Jones, and with me is attorney Mark Brynteson with the American Law Firm. And you're watching Legal Matters, an informational and news call-in show devoted to a variety of legal topics. Attorneys are standing by now to take your call at the number on your screen. That's 815-394-1776. They'll provide you with free information regarding your issue, so call now. The lawyers will be standing by until about 7:30 tonight. So, Mark, now we're going to switch gears a little bit and move on to the topic of bankruptcy. Is that something for everybody?
It's not something for everybody, but it could be a very good thing for some people, especially with the way the economy has went in the last few years. One thing that we see is because the value of houses have went down. People's mortgage, it's more than what the value of the house is, and if they're foreclosed on, they can be held liable for the difference in that price. If there's a short sale, if you don't work the short sale out correctly, which we do handle, people can come and see us. A short sale is when you sell the house for less than what it's worth. There's going to be an amount owed to the bank. You have to make sure that they're willing to forgive that during the short sale. That's still going to ding your credit a little bit, but it's better than owing the bank that amount of money. So bankruptcy in some cases is really a remedy for somebody. We've got to remember, the bankruptcy is in the U.S. Constitution. It's a constitutional right. But just like guns, the United States Congress can pass laws that regulate your access to bankruptcy. And about 15 years ago, they rewrote a lot of the bankruptcy laws that made the hurdles higher to jump over to be able to declare bankruptcy, which is really too bad in some respects because they make it very costly for the person that's going to declare bankruptcy at a point when they don't have any money, and that's purely the creditors. They want that person not to declare bankruptcy. They want to be able to go after that person to get their money.
It's frightening. A lot of people are just strictly afraid of what it will do to them right off the bat.
Well, you know, one of the things we see routinely is when somebody declares, well, I had a client that called me not too long ago that after the bankruptcy, 3 years, and their credit score was back to almost 800. So you still have the bankruptcy on there, but if you know how to play the credit score game right, bankruptcy, you can leave the consequences of that behind pretty quick. The question is it the right thing to do at the time? So when you come in and you talk to us, we try to go through a total look at your financial picture and see, is there any debt workout possible? and we'll go through a couple other options before we get to the bankruptcy. And then when you get to the bankruptcy, if it's an individual bankruptcy, it depends if it's a Chapter 7, which is a complete liquidation, or a Chapter 13, which could take maybe 3 to 5 years.
Okay. Well, that was the next question. There are different types of bankruptcy that's out there.
Sure.
I mean, personal and business. I mean, there's Chapter 11. So run through those again real quick.
Well, the Chapter 7 is what they call a complete liquidation. What people need to understand, though, is there may be a way to keep your house in a complete liquidation, keep your cars. You have what's called a homestead exemption, which will automatically, let's say this, let's say you have a car that's worth $25,000 and you owe $15,000. You can theoretically, that's equity that the bankruptcy trustee, they could take the car and sell it, get $10,000 of equity and go to pay off your creditors. Well, you have a homestead exemption for personal property that you could exempt that amount and keep the car. Same thing with real estate. So there are some positives in the bankruptcy process if your debt is really Mount Everest sized, that you can still keep a lot of your assets, including your home, including your car.
Okay. So it's best, again, contact an attorney and get it all laid out and fully understand the situation, simply because as complicated as it is.
That's absolutely correct. And talk about a Chapter 13. A Chapter 7 is usually over maybe 6 to 8 months after you file the bankruptcy petition. But a Chapter 13 is a wage earner. It's a little bit easier on the credit score. But what a wage earner is, and a lot of creditors will look at a Chapter 13 when after you're done in terms of extending your credit. That may be the ticket that will allow you to get a house sooner, allow you to get a car sooner after the bankruptcy, because they'll see you wanted to work and at least try to pay your creditors off. And what a Chapter 13 does, it's not a complete liquidation, but what it is you come up with a plan and you give it to the trustee, and it may say over 5 years, I may be able to pay off 40% of my debt, and after 5 years you pay 40% of that debt off, then the other 60% is forgiven. But in that you may be able to keep your house and your car. So there's a lot of analysis that needs to go on, and there is some interplay between state law and federal law regarding the homestead exemptions as to what you can keep and what you can't keep. So it's important to come and see an attorney to go through that so that you don't miss any of it.
Okay. And the number to call, by the way, to get this information, of course, is 815-397-1776. And one, I guess, what does a person decide that they have to declare bankruptcy? What point is it in their financial life that says, I got to get rid of this?
One of the things we look for is how old are you, where are you at in life. If you're younger, you certainly can declare bankruptcy and recover quicker. If you're older, you may not be able to. So we look at a whole span of issues to determine if bankruptcy is the right thing, and it could be your age at the time.
Okay. Thank you very much, Mark. That's it for tonight. We'll be back with our closing statement in just a few moments.
Picture experience. Legal experience in many areas of law. Dedication. Giving full attention to each client and their individual legal needs. Affordability. Offering simple flat fees and payment plans. Now picture the American law firm. Call the American Law Firm today at 815-394-1776 for your free consultation.